Hi. So a very good afternoon to all of you all. Now we begin the particular three criminal laws from the latest ICSI study material. Now ICSI has issued the three criminal laws in the supplement sheet. From the supplement sheet, I will be teaching it. I have concise the entire notes. You all can be with me and complete the chapter with me. Okay, I am covering everything. There are a key few changes also, and all the things we will be doing after this. There will not be any single topic left out from the three criminal laws. Okay, so in a span of 3 days, I will be covering the next 3 days. I will be covering the full chapter in depth from the ICSI study material. Okay, and just remember one thing that you can share it with your friends and also in your study groups. Okay, so good to go. Can we start? I need a GTG in the chat box before I start. Okay, GTG in the chat box, please. Good to go. Okay, yes. So you can keep your study materials open, and for our students we will be sending the notes also. We'll upload directly in the app, so the students will be able to get the notes also. Okay, and for students who are regularly attending, for few students I will give the notes also, especially these notes which is there. Okay, so now Vishnunath, great to have you. Let's start. Okay, just okay, great. So let's begin. Hi, so now we'll be starting the three new criminal laws. Now, the very first law that is called as the Bharatiya Nyaya Sanhita or the BNS Act. The BNS Act is actually the India's criminal code of India. Okay, it is the criminal code. Let's see. So it's called as the Bharatiya Nyaya. Nyaya means justice and code means Sanhita. So the Bharatiya BNS Act is the official criminal code of India. The criminal code of India or the law of crimes, this will also be called as the law of crimes. This is the law of crimes. Before this, the law of crimes was called as the Indian Penal Code. Indian Penal Code was a colonial law. When I say colonial, means it was drafted under the British rule, under the rule or under the chairmanship of Lord Thomas Babington Macaulay. So Macaulay had actually made the three criminal laws. Okay, it got repealed after many years. In 2023 it was repealed and it came into effect from 1st July 2024. Okay, so BNS Act replaces the law made by Babington Macaulay, that is the IPC code, and it came into effect on 1st July 2024. Next, a few kind of replacements were done. Okay, the three criminal laws were replaced. First, the BNS Act replaces the IPC code. The BNSS Act replaces the Code of Criminal Law, and the Bharatiya Saksham BSA Act replaces the Indian Evidence Act. So these were three major criminal laws which got replaced, and now we will see the three new criminal laws in our part. First we talk about BNS Act. Now BNS Act has around 358 sections. It has been concised from 511 sections of the Indian Penal Code. So Indian Penal Code had 511. Now it has been shrink down because many offenses were outdated. They have removed it, like your sedition has been removed. Okay, and they have made your homosexuality has been removed. Okay, and now we have concised it into 358 sections. Now what was the key changes? Some additions and changes in the law of crimes. First, they introduced new kind of offenses which was not there earlier. For example, your snatching was there. They abolished, that is removed, three main laws. Okay, three main things. One is sedition law. If you speak against the government, you used to be jailed. So the Britishers used to use this to harass the Indians. So sedition has been removed. Attempt to suicide has been decriminalized, because now we believe that attempting suicide is not a crime or a criminal act. It is more of a mental issue than a real criminal act. Okay. Next, you go to see transgenders, homosexuality has been removed. Okay, as a crime, it has been removed. They've introduced new ones like snatching has been introduced and mob lynching has been introduced. Okay, so they have introduced three things. You can say mob lynching as a mob lynching. They have introduced your snatching, and they have also introduced something called as a community service. Community service means what? For petty small offenses, what they will tell you that go ahead, clean the washroom, clean the road, give work with a NGO. For petty thefts, they have made a new kind of a punishment which is called as community service. So these have been newly introduced. It has been new to be introduced. And something which they have omitted or removed is, for example, sedition has been removed. Your homosexuality has been removed. Okay. And attempt to suicide. Attempt to suicide. So if someone tries to commit suicide in the Indian Penal Code, it was punishable, but now it is not punishable. Okay. Begging has been criminalized, and they have removed terms like crown, British India, queen. Okay, this is all they have introduced. Your begging as a forcing someone to beg is considered to be an organized crime. This they have newly introduced, and they have omitted the words such as crown or British India. Okay, so these have been removed and these have been newly inbuilt. Now, one very important thing, very important, which they can ask you, we always used to call as the law of crimes. So whatever, whether it was the Indian Penal Code or now the BNS Act, they were called as the law of crime. Interestingly, in the new law, the word crime is only not mentioned. In BNS Act, the word crime is only not mentioned. Can anyone tell me or think what is the real word for a crime, for a criminal act? So earlier we used to, whenever anyone used to do a criminal act, it was called as a crime. Now it is not called as crime, it is called as a offense. So they have completely substituted the word crime and said offense. So what do you mean by an offense? It is given in your section 2 subsection 24, which means offense means a thing punishable by the BNS Act. So anything made punishable is crime. No, it's not a crime. They call it as a offense. It can be, the meaning is the same, but they have stuck to the word offense throughout the act, and that is why not a single word of crime has been mentioned in the entire BNS Act. Okay. Now, crime is a social phenomena. Now, whenever a crime is being done, it is done as though it is a wrong to the entire society, because it mentally affects the entire society. Imagine if your neighbor has been murdered. Wrong has not only been done on him, but to everybody in the society, because everybody will now get scared. And normally for crimes, the state will take action, the police will get involved and proactively try to solve the problem. So in criminal matters, state comes into play, but for civil matters, which are not crimes, property matters, all of that, you have to contractual violation. You yourself have to take action. No court or government is going to come to help you proactively. Okay. Now, we understood the law of crime is the Indian Penal Code, which is now called as the BNS Act. BNS Act. It is a substantive law. Now let's understand the meaning of the term substantive law. A substantive law is a law which defines what rights and duties you have, and it tells what penalty you should have. That's it. So what does a substantive law give you? It covers a definition of murder, extortion, dacoity, all those they will cover the definition and the quantum of punishment. So the BNS Act has various offences. They define the offences and they tell that for the offence how much punishment will be there. So it's a substantive law. But let's say if someone has committed a murder, then what will be the procedure of FIR, remand, judicial custody, bail, appeal, anticipatory bail? So all that entire process of handling a crime, the procedural aspect is covered in a procedural law. It covers the procedure to be followed and how much time the accused has to be brought before the magistrate, how much time the entire panchnama will be made. All of that is mentioned in the procedural code. Now the earlier procedural code which was there was called as the criminal procedure code, and now it has been substituted with the BNSS Act. So the BNSS Act is the procedural law. Now what is the BNSS? Bharatiya Nagrik Suraksha Sanhita. So Suraksha means protection. So to protect the people, a proper procedural law is in place. Let's see. Bharatiya Nagrik. Now we are seeing a small little highlight of the BNSS Act. So BNSS Act is nothing but a procedural law to be followed in criminal matters. It replaces the CRPC. Now let's see, the CRPC 1973 which was there, okay, this was formed by a law commission. Now we are going to into the history under the Justice KVK Sundaram. So Justice KVK Sundaram was there. He drafted the CRPC. Now it has been repealed. Okay, the British era procedural laws have been replaced with the BNSS Act. Clear till here? So your substantive law is BNS and your procedural law is the BNSS. Clear? Let's see further. When we compare the particular criminal laws, it is more or less the same. The procedural aspect is a detailed procedure for everything, including timelines have been given. So in CRPC there were around 484 sections. In the BNSS Act there are 531 sections. What were the key changes in the particular BNSS Act? Okay, BNSS Act we are seeing is the investigation, the procedure. They have said that now the police officers have to complete their investigation for a little lesser serious matters within 60 days. So investigation must be completed within 60 days if the offense is of up to 7 years. Beyond 7 years they get more than 60 days, obviously, because it's a very big crime. Now in the procedural aspect and in the evidence aspect, now they have said that even we will allow e-FIRs and e-complaints to be filed. So if you have seen that if you come to know that there's some crime going on, you can go online and complain. There is a e-complaint can be filed and the officer can file a e-FIR also. WhatsApp, CCTV image, digital records are all admissible in evidence also. So even during the procedure, all these evidences can be taken. Women have been given larger protection. Mob lynching has been addressed, and also in the procedure, if some witness is coming and giving some witness with some aspect that I have seen this crime, etc., they will also be protected. Okay, so proper enhanced witness protection has been given. Now the question is, why are they putting in the company secretary syllabus, or why should professionals like CA, CS, CMA have to know these criminal laws? So now when you go to see in your Companies Act, many times it has been written that punishment is of imprisonment or fine or both. So as a company secretary and other professionals like CA, CS, though they have limited involvement in all this, we don't deal with murder, extortion, dacoity, but we definitely deal with matters with criminal liabilities for directors, company secretary, officers, and that is why knowing the procedure to be followed is very, very important. Okay, now we will start with the BNS Act. The Act starts with the applicability. Always section 1 of any act will tell you two things. It will tell you the name of the act and it will tell you its applicability. Till where all does it apply? So BNS Act applies to the whole of India, okay, including Jammu Kashmir. The entire India is covered. Now, jurisdiction means what? What do you mean by the term jurisdiction? That where the act will apply. So where all they can, if the act is applicable here, let's say if there is a foreign citizen and he has done a crime in foreign country and it has no connection with India, courts will not take up the matter because they will say it's not in our area, it is not in our scope. It is not in our scope, jurisdiction. Now we will see the jurisdiction. Jurisdiction has interestingly been defined in two categories: intra-territorial and extra-territorial jurisdiction. So jurisdiction means the scope of the act, where all it can apply, okay, within the boundary of which it can apply. So we will see what is extra-territorial jurisdiction and intra-territorial jurisdiction also. First, crimes committed in India. Let's say if there is a robbery in HDFC Bank, Mumbai, will this act apply? Yes or no? Obviously it will apply. Why? Because the crime was committed within the Indian territory. So it is an intra-territorial jurisdiction, that the act has application powers to take up matters if the crime is within India. But does the particular act also have powers beyond India? Can a court take up a matter and apply this code, apply the penalties if a crime is committed outside India? So the answer is yes. Limited extra-territorial powers have been granted, that crime outside India can also be punished in as per the Indian law if there are some conditions, if it is affecting the sovereignty, integrity of India, or an Indian citizen has committed outside India. So still once he comes into India, we can take him into action. So let's see each of them. So there are how many jurisdiction types given? So there are two jurisdiction types. One is intra-territorial jurisdiction, very simple. And let's see. I'll ask you certain questions. That first, an Indian citizen has done a crime in India. Will the code apply? Will BNSS Act? Will BNS Act apply? Yes or no? Yes. Obviously, this is a simple one. Let's say a foreigner has come in India and he has done a crime. Can we take up the matter? Again, yes, because any person, whether Indian citizen or outside non-Indian citizen, does a crime in India, we can take up the matter. So any offense committed within the within the territory of India is covered under the BNS Act, regardless whether the accused was an Indian or a foreign national. Okay, the courts have the power to try and punish the offender. Extra-territorial jurisdiction given under section 1, subsection 4 and subsection 5. So section 1, subsection 4 and 5 talks about territorial jurisdiction, where the act will apply even to cases outside India. Let's see when. The BNSS Act extends to India borders also if it applies to one Indian citizen committing an offense outside India. So if an Indian citizen has gone outside and committed a murder, Indian courts can also take up the matter when that person comes into India. Second, a crime committed on a Indian registered ship. This is called as a Admiralty jurisdiction. What it is called? As a Admiralty jurisdiction, where you do a crime on a ship which has the Indian flag. Now Indian flag, if a ship has, so it is being treated as a ship is a floating island of the country of which flag it has. So for example, if this is a Switzerland flag it has, so then it will be a floating island, as though it's a floating part of Switzerland done, any crime done here, no matter where the ship is there, running, moving, stationary in any other country, any other waters, that particular country can take up the matter. Who, if it contains the nation's flag. So that's called as Admiralty jurisdiction. We will come to it. Okay. So Indian registered ship, regardless of its location, the act can take place. Cyber crimes now obviously committed outside India. So now let's take an example. This is there. They live in Spain and they are trying to commit a robbery on an Indian bank from outside India. So yes, they will be, action can be taken on them. Second, if you go to see, there is Pakistan. In Pakistan, there are some software engineers who are coming to hack the Indian government website. Will that also be an offense? Answer is yes, because you are trying to do a crime in India. Even if you are abroad, we can still try you. Okay. So let's see. So which is the extraterritorial jurisdiction is covered under section 1 subsection 4 and 1 subsection 5. Simple. Let's see. Illustration. A Indian citizen commits a murder in a foreign country. Will he be tried? Answer is he can be tried in the Indian court. Simple. Second, a foreign hacker, as I told you, a Pakistani software engineer is trying to launch a cyber attack on the Indian banking system. He can be prosecuted under the BNS Act as well. Then we see a legal case law. Case law is also very important. It is called as Mubarak Ali Ahmed versus State of Bombay. Okay, Mubarak Ali Ahmed versus State of Bombay. What did they say? It is concerning a foreigner. It is concerning whom? Foreigners. Now, a foreigner committing a crime in India. A foreigner committing a crime in India. Will he be tried? Yes or no? Yes, he will be tried. But my question is that he says that I have an ignorance of law. I am from that country. I know that country laws. I don't know Indian laws. So will that defense be valid? Yes or no? So obviously the ignorance of law, Indian law is not a defense for foreigners, is what was mentioned in Mubarak Ali Ahmed versus State of Bombay. A foreigner was prosecuted under Indian law even if he was not aware of the Indian law. So ignorance of law is not allowed even for foreigners. If you come on Indian law, better read the Indian law and you come. Okay. Now, exemptions from intra-territorial jurisdiction. Now imagine there are some exemptions where BNS Act will not apply. Imagine a very, very important thing where the BNS Act will not apply. Tell me one thing, can we put a president or governor? Can we prosecute them under the BNS Act? What do you think? Yes or no? A president has committed a murder. Okay, can we try that president? Yes or no? President of India, governor of India under the BNS Act. So the answer is no. So does that mean that even if he's a president, he will not be, he can kill whoever he wants? So the answer is, listen, the tag, the designation that he has is very prestigious. It affects the Indian government. So what you have to do, first he will be removed from the president post, he will have to resign, and then a proper procedure will start. So when procedure starts, he should not be a president or governor. So either he will be removed or he will be, that's called as impeachment. If you know that Donald Trump was the first president who was impeached, and because they had to take some criminal action on him. So during his, when he is a president, no action will be taken. When he's changed, then you can take the action. So president governors are exempt. Okay, this is the Constitution of India saying, Article 361 sub article 2. Second, even when foreign sovereigns, like for example, there might be Obama coming, there might be Donald Trump coming, there might be any foreign national or foreign sovereign diplomat coming, and they jump the signal. So no action will be taken. As per international law, foreign heads, diplomats, all of this can enjoy legal immunity in India. Okay. So this has been given and respect has been given to them so that we can maintain our friendly relations with a person also. Now we come to Admiralty jurisdiction, which I've already done. What does Admiralty means? With respect to waters on ships. So a aircraft or a ship, let's say there was a plane which got hijacked. They took the entire plane. It was an Indian airline. It was an Indian aircraft. It was taken in Pakistan, Karachi, and murder was done on that particular flight. So administrative jurisdiction will apply. It means that, listen, a ship or an aircraft, if it contains the Indian flag, it is of Indian origin, it's an Indian registered ship, then it can be taken under the BNS Act even if the offence is committed in airways, waterways, abroad, international thing. Okay. The principle is it is treated as a floating island. I told you it's treated as a floating island belonging to the nation whose flag the ship or the aircraft has. This jurisdiction is called as an Admiralty jurisdiction. Simple. So if a murder has happened on a Indian registered ship in Germany, the crime will be prosecuted under the BNS Act in a Indian court. Simple. Now let's see, I told you section 4, 1 subsection 4 and 1 subsection 5 mention this. So what we will read now is the extra-territorial jurisdiction. We will be reading the application of the act beyond the territory, which we just read now. So recap will be done. First, earlier this section we don't need to know, but just remember now it's section 1 subsection 4 and 1 subsection 5. Under the BNS 2024, the scope of the extraterritorial jurisdiction has been expanded, ensuring that Indian courts can prosecute offences which have been committed abroad, even if they involve Indian citizens or if they involve Indian citizens or Indian interest. So Indian committing a murder abroad will be counted. A foreigner, Pakistani person trying to hack India website will also be covered. Subsection 5 also says that crimes committed by Indian citizens abroad are covered. The BNS Act applies if you have done a crime abroad. Crimes occurring on registered ships, so same thing we have read, and crimes committed from foreign countries targeting Indian digital infrastructure. So we've seen extraterritorial jurisdiction. So intra was simple, extra is also very simple. In extra you have to remember section 1, subsection 4 and subsection 5. Okay. Now we'll see the stages of a crime. Okay, stages of its crime and its punishment. So we'll be seeing the punishment also. So in a stage, it starts with 4 levels. 4 levels are there for a stages of a crime. So the first level is the intention, that I should have a mens rea, I should have a guilty mind, I should have the criminal intention to do the act. Intention. First starts with the intention, I want to kill that guy. Then in order to kill that guy, you will make some preparation. You will load up a gun, you will sharpen your knife, you will buy a hammer. So anything, however you want to kill him, you will be ready. It's called as preparation. Third will be an attempt, and fourth will be the actual commission of the offense. So in this stage, so I have the intention, second I will prepare for it, third I will attempt, and fourth I will do the actual commission of the offense. Now you tell me, from here, which all is punishable? Which all will be punishable? Is a criminal intention punishable? Yes or no? So the answer is criminal intention is never punishable, never. Because obviously you have an intention, so many times we might have an intention to kill someone, to slap a person, to beat up a person, but we never do it. So intention, obviously, if it has not done any furtherance in thing, not punishable. You can change your thoughts. So evil thoughts are not punishable. Second, I start preparing. I load up a gun. I sharpen the knife. I start making my body in the gym, and I'll beat him up. So it is normally never punishable. However, there are some exceptions, and these exceptions are important. These exceptions are important where preparation also is punishable. Preparation also is punishable. we'll see, like we are waging a war against a country, we will not wait for you to do the war. At the time of preparation stage only we can we will arrest you. Attempt again is you here we have attempt to murder, attempt to attempt to kidnapping, attempt to theft, that is also covered, so that is also punishable, and actual commission is obviously punishable. Let's see each of them in depth. Fourth, let's start. There are 4 stages of a crime. Okay, 4 stages. The first one starts with a criminal intention. Tell me one thing, does the law punish evil thoughts? So generally the law does not punish an individual for having criminal thoughts alone unless they do furtherance of something in that. Okay, a mere guilty intention, so maybe my thoughts are very difficult to prove in court, therefore they are not even punishable. Okay, criminal intention in the first stage, it refers to a deliberate exercise of a person's mental facilities to achieve a particular unlawful purpose. So I picture the entire crime scene, still it is not punishable. Okay, now why? Legal intent. Now understand, sometimes intention is very difficult to prove. Intention is difficult to prove because I will say no, it is not there in my mind. If law, what do they do? In certain matters, they fix the intention on you. They will say, listen, I feel you have the intention. Okay, intention is presumed. Let's say the example, perfect example is driving recklessly and killing someone. So it will be presumed that driving, if you intend to drink and drive, you actually knew that drinking and driving can cause injury to someone, and if it did, we will presume that you have the guilty mind. Okay, intention can be inferred from a person's action. So from your actions, I can decide, if I threw a sword at you, obviously I have intention to hurt you. So intention can be presumed from the person's action. Simple. BNS Act presumes intent in case of reckless behavior. So if a person is drinking and driving, it is going to be presumed that he has the intention of killing someone by default, because drinking and driving can cause death or harm to someone. Now we come to preparation. I told you preparation normally is not punishable. Why? Because you can easily back out. If I don't attempt only, then how I have not done anything wrong. So it is difficult to prove an individual was preparing to commit the crime. I say I'm just making my body like that only to impress someone. I don't want to kill him. I bought this hammer to fix some broken table is there. I bought it for that. Okay, I bought a gun for self-defense. So again, preparation is not ever covered in the offense. However, they have said some cases where preparation is also punishable. Preparation is punishable. Very, very important. It's a past exam question. You should know. When preparation is punishable, base rule is that it is not punishable, but sometimes it is punishable. One, if I am preparing to wage a war against the government, obviously it's going to be punishable. Second, I am preparing to counterfeit currency notes and government stamps. So fake currencies, fake notes, fake stamp papers, I am preparing to do that, again I can be punished. Third, again, fake coins, fake weights, forged documents, preparation, possession of all this is considered. So even if I have a fake coin in possession, it will be treated as a offense and I can be punished. Next is preparation to commit dacoity, that is robbery of 5 or more persons. In robbery, you alone take it. In dacoity, 5 or more people come together. So in all these cases, even preparation is punishable. Clear? So what are the cases? One is waging a war against the person, then second is having fake notes, fake currency, fake coins, and fourth is dacoity. So dacoity, fake notes, fake currencies, fake coins, and waging a war against the government. So these are the 4 preparations which are punishable. Now we come to the third one, where a little more act has been done, where you have attempted to do the crime. Maybe you must have failed. Okay, you couldn't commit the offense. I shoot someone, but the bullet did not hit him. So an attempt is a third stage in the commission of an offense. Attempt is considered as a preliminary crime because it is a direct movement towards the crime. So offense is there where you have actually done, and the other one is I've almost come close to doing the offense. So attempt is obviously punishable. Section 62 provides that punishment for attempt but does not define what does attempt mean. So attempt, what it is, they've kept it open for judicial interpretation. They've not exactly defined attempt, but they said you move forward to do the crime. You take some steps. Attempt could be understood that you've taken steps towards committing the crime with proper preparations. Let's see. Types of attempts has been recognized. Types of attempts recognized under the BNS Act. First, some attempts are equivalent to crime. Some attempts are equivalent to crime itself. They are treated equally. Most important is waging a war against the government, means it is one and the same. So offense where both commission and attempt are treated equally, same punishment for both. Waging a war against the government, sedition, bribery, dacoity, all these cases, whether you attempt or you actually do, the punishment is the same. Next is offense where the attempt and commission are separate with different punishments. Now in the BNS Act, sometimes they will tell that if you've done murder, this is the penalty. If there is an attempt to murder and it was a failed attempt, the person survived. So attempt, there is a separate category given and separate punishment given. So if separate commission of the act has been given separately and attempt is given separately, then obviously they will be treated separately. They will be treated separately. Attempts can be recognized separately. Sometimes it can be same as the offense, sometimes it can be treated as separate. Third category, attempt to suicide under coercion. Now understand one thing, attempt to suicide, whether it is punishable or not punishable under the Indian law, BNS Act, punishable or not punishable? So the answer is it is not punishable, it has been decriminalized. But if you read, they have said that if I am threatening a government official, a government officer, that if you do this, I will commit suicide. So your taking life is being treated as a weapon. I tell you, you better give me 1 lakh rupees, otherwise I'll burn myself. So this becomes a coercion. I'm making a person do something under threat or force that I will kill myself. That is punishable. Attempt to suicide for instigating a person to do something is treated as a crime. For example, someone just attempted to suicide innocently, did not get good marks, tried to attempt, kill themselves, but then later survived. No crime, nothing will happen. But if imagine a police officer has come, I tell them that listen, if you try to come to catch me, I will jump down the building. So I am threatening to commit a suicide. This is punishable. Okay. The general provision for all other attempts do not specifically provided. Now imagine if normally they might have you murder and attempt to murder might be two different things. In the BNS Act only there is separate punishment. But let's say if there are no separation given, then they are saying half. Then punishment, what should be the attempt penalty? Half of what it would be given for the full offense or fourth. So for example, if you have committed it is punishable with 6 years. Maximum punishment that can be given for an offense is 6 years. If you attempt to do it, then punishment can be given half, that is 3 years. So if specifically attempt has not been defined as a punishment, then if you attempt to do an offense which is not been mentioned, then half of the penalty you may get. Okay. Next we see commission of a crime. Commission. Now this is the actual commission of the crime where you have done it. Obviously it's the final stage and you've accomplished the person has accomplished the criminal act. Okay, so in that case, obviously you will get the punishment as defined under law. Now, what kind of punishment you will get? They have added a new kind of punishment here called as community service. Very, very important. So, what are the types of punishment they have given you? First is the most serious, and in rarest of rare case, they have given you, which is called as death. Lesser than death, it could be life imprisonment. For your entire life, you are in jail. They might define also life could be in 7 years, 14 years, 21, or actually life. Third is imprisonment has been given, whether it could be simple imprisonment where you're just jailed, or second is rigorous, where you also have to hard labor is involved. So you not only have to do, you're not only jailed, but you have to do work also inside the jail. That is called as rigorous imprisonment. Then lesser than that, forfeiture of property. If the government has called you, you've not come, if you've done some economic offense, they can take away your property also. Fine is a another monetary penalty. Now let's understand the types of punishment under the BNS Act. Okay. Right from the highest is penalty, death penalty, and the lowest is community service. So let's start with the highest first. Is death penalty given in many cases or in few cases? So remember that there was a case law of Bachan Singh versus State of Punjab, where it said that listen, under the BNS Act, it involved that rarest of rare cases only death penalty can be given. Death penalty can be given only in rarest of rare cases. Concept clear? As per Bachan Singh versus State of Punjab. So rarest of rare means extremely rare cases this can be given. Now under the BNS Act, the following offences have been death has been given for these offences as a maximum punishment: murder, dacoity, war against the government, okay, abetting mutiny actually committed, okay, which is going against the government or the army, giving or fabricating false evidence leading to an innocent person death. So you gave a false evidence because of which a person died. Abetment to suicide by a minor or an insane person. So you encourage a child to commit suicide or a insane person to commit suicide. Attempted murder by a life convict. So already you were in life imprisonment and then you try to do something, you can get a death penalty. Now new offences that has been also included with death penalty, that is mob lynching and terrorism. For them also death penalty has been introduced. Organized crime also, they have said that it could be 10 death can be given as a penalty. Now lesser than that is life imprisonment. Means it could be two kinds: simple imprisonment or rigorous. In rigorous, the person has to do throughout the life obviously, but along with hard labor. Okay, when life imprisonment is means rigorous imprisonment for the entire natural life. So you have to remember that life imprisonment, when we say, rigorous imprisonment will be given for his entire life. Now what we were saying is simple. If you are given imprisonment, not life imprisonment, imprisonment for 3 years, 4 years, 5 years, then in that case it could be divided in two categories: simple, where there is no hard labor, and rigorous, where there is hard labor, that you have to do a lot of hard work to get your roti or to get your food, etc. Then comes forfeiture of property. In forfeiture of property refers to loss of property as a punishment for certain offences. Section 154, 155, courts can order forfeiture of an offender's property where they have done some economic organized crime. So for forfeiture, they can forfeit your property if you've done any organized crime. And lastly is a fine. A fine is nothing but a monetary penalty imposed by the court. It goes to the government, okay, and the fine should be imposed on individuals and not collectively. So fine is on a specific person, that you have to pay so much money. So these are the thing which was there earlier, but now they have introduced something new which makes it very, very important. Okay, what is it? It is your community service as a punishment. So community service is the lowest form of punishment for petty offenses, for petty or minor offenses. Okay, why? The objective is that nowadays courts are already overburdened, jails are already overburdened. So why put a person in jail for small offenses? We can tell him that go ahead, do some community service, clean the roads, clean the toilets, plant a tree, or work with an NGO. All of that is covered. So this is the purpose, is to restorative justice, that we give you justice, that little bit of punitive action will be taken, and you please, this is the form of justice that we are giving. Already the prison system is already overburdened, that is why we go for introducing this. It is already aligned with the international best practices. So United States and all the worldwide, they are giving community service, encourages a collective approach rather than just a punitive one. So instead of person always punishing a person, you tell a person to do some positive acts, okay, and it positively contributes to the society also. You can tell them to go ahead, help certain senior citizens, etc. Now, offenses eligible for BNS Act. Now, not all the offenses can get such community service. The code allows to impose immunity service as an alternative to imprisonment for minor offenses. The specific offenses for which community service can be ordered are included here. A public servant engaging in illegal trade. A public servant involved in unauthorized trading activities may be allowed to ask a performer community service. So, for example, a public servant, officer, municipal officer has done something wrong, dealing, buying, selling of something which was not allowed. So we say, okay, fine, give a community service and finish it off. Failure to appear in response to proclamation. So normally court summons an accused. If he doesn't come, we send a second summons notice that you please come. If he doesn't come, then we proclaim him as an offender, and then we can even take away his property. Okay, or if a person is not coming, then proclamation has been given and we tell them within 60 days you come. He did not come, then when we catch him, we can give him that, community service, go ahead and do. Attempt to suicide can be given to influencing authority. I told you, when you try to threaten an officer by committing suicide, that I will commit a suicide, then community service can be given. First time conviction of petty theft. Petty means small theft up to below 5,000 rupees. So 5,000 rupees is the limit. Below that, if you've done anything wrong, for that much amount you can get community service. Public misconduct by a drunken person. So section 355 is basically, if a drunken person has created a ruckus, then once he is in sane mind, we can tell him do community service. Defamation, okay, for defamation also one of the punishments could be your community service. Okay, implementation of community service in the BNS 2023, it replaces the traditional punishments of imprisonment and fine with community service, but only for specific offenses. Okay, like what are the services that can be told? Cleaning a public place, okay, assisting a NGO, or helping rehabilitation for victims or crimes of disaster, etc. So all these, planting a tree, all this can be done. Now you see, many times they use the word fine and penalty interchangeably. What is the difference between fine and penalty according to you? What is the difference between a fine and a penalty? So remember, a fine normally is for criminal matters, and penalty, when they use, is mostly for civil matters like Companies Act, etc. You will see the word mostly penalty used. They use it interchangeably, but if you go into the technical sense, technical meaning, then we'll see the difference. So difference between fine and penalty. Okay, let's see difference between fine and penalty. First, what do you mean by fine? There's no actual definition under law. It's just a common understanding. So we had seen. So we'll use the dictionary, Webster's dictionary, where it says a fine is a sum imposed as a punishment for an offense. That means criminal act. So whenever in your BNS Act, you'll always see fine mentioned. Definition of penalty: fine is for criminal and penalty is normally used for civil matters. So referring to a sum to be paid or forfeited, for which a person agrees to be submitted in a non-fulfillment of stipulation. So Penalty could be that you've not completed some requirements, some form filing was done late, so penalty will be imposed. Key difference, what is the key differences we'll see? Nature of default. A fine is imposed as a punishment for an offense, whereas penalty is imposed for non-compliance of any rules or regulations. So if you have not done the filing, if you have not complied with certain procedural aspects, then penalty is given. Fine is when you have done a criminal act. This is the technical thing. Then even when you go to the section 2 subsection 38 of the General Clauses Act, offence is defined any act which or commission punishable under the law in force. Non-compliance refers to failure to comply with the legal requirement. This is your penalty. So non-compliance of a law is maybe I didn't do something, so that is a penalty. But if you do a criminal act, then you have a fine. Usage. Now very simple. This is done. Fine is in criminal, penalty is in civil laws. This is the most important. Now when we go into the company law, we see that they mention that penalty is there. Now when penalty is there, if you fail to comply with the requirements of section 12. Section 12 relates to registered office. Certain form filing has to be done. If you've not done, then penalty will be imposed. Whereas you see fine has been done for any criminal act, wherever imprisonment is there, etc. So that time they use the word fine. Fails to comply with the directions, it is punishable with fine, or this an officer may be fined up till this much amount. Your default is classified as an offense, hence fine is imposed. So whenever crime is involved or criminal act is involved, where imprisonment can be there, they use the word fine. Okay, now fine and imprisonment when both apply. In cases where there is serious, fine and imprisonment both can be given together. So we see so many times for serious offenses, fine and imprisonment is also given. Otherwise you will normally see fine or imprisonment or both is also given, right? So for serious offenses like violation of your section 8 NGO, fine and penalty both can be given. Fine and imprisonment. You're also in section 26 subsection 9, which talks about violation of a thing in prospectus. You may get fine, penalty or both. Comparison between regulatory laws. So even SEBI, they have a power to apply not only fine but also imprisonment. So they give the wordings fine, imprisonment or both. What is the difference? Fine is mostly for offense, criminal laws, and it normally be tagged along with imprisonment, and it is used in mainly criminal acts or provisions. Whereas penalty is for non-compliance of something, it's a regulatory lesser thing. No imprisonment is given normally here, and non-comply with procedural laws is covered under the penalty aspect. That is it for the first part. The balance part we'll do in the next video. Thank you. Okay. Till here it is clear, everyone? Yes or no? In the chat box till here, is it clear? Yashi, we will be starting with group 2 in the next week. Don't worry, that will also be started. Okay, everyone else till here you have understood completely? In the chat box, yes or no? Clear in the chat box. Mention clear in the chat box. Have you understood? I'm just waiting for your responses. Okay, Sona, great. Vishnunath. Okay, so Nandu, thank you so much. What is a floating island? Nandu Krishna has asked what is a floating island. So they said that a ship on which an Indian flag is there, if it is sailing anywhere, it is treated as a floating island. That is it. Okay. Madhav Raj, great. Katiroli, great to have you. Okay. So now this is done for today. I will see you all tomorrow with the continuation of the chapter and we will complete. Now it is possible that I might not send the YouTube link. It might be a Zoom link where I will be able to interact with you as well. So please join the WhatsApp group, share it with your friends as well. Okay. And get geared up because a lot more is planned for you all. That's it, guys. See you all tomorrow. Take care. Bye. Can community service be awarded to minors? Answer is no. Minors cannot be awarded. They are treated in a separate manner altogether. They have been given, not under the IPC. They are not a crimes, and the crimes they cannot become. There is a different law which they might give you. Community working with an NGO is a separate thing, but not as a punishment under the criminal laws. So that cannot become. Good question. Community service cannot be awarded under these law. There is a separate framework which is made for them, in which they make them do community service. That is there. Okay, that is it. Thank you so much, guys. See you all tomorrow. Bye.